Hey, this is Vema, and this is my podcast. And today I've got Chris with us today. He's an estate planning attorney. And as most people know, we're all going to die, but many of us don't expect and don't have a plan for how we're going to deal with that. And so today I've got Chris, estate planning attorney, who's going to give us a little details about that and how that relates in real estate. So if you can, Chris, kind of give us a little bit of an intro about yourself.
Yeah, so I'm an estate planning attorney. I'm practicing in Austin, Texas. Basically, what I do as an estate planning attorney is I help people put together plans that anticipate major events like death and incapacity. And I also help people sort out the legal end of things after someone has died. So, you need to clear title to real estate before you can sell it. I help them sort all of that out in the probate courts.
Okay. One thing I get a lot of questions about is what trusts are, how does one set it up? If you can kind of give us a little bit more insight into that.
Sure, yeah. So there are two basic ways to go in the estate planning world. There's the trust-based plan and there's the will-based estate plan. The will-based estate plan, in that case, the will is going to be the main vehicle for passing your estate to your beneficiaries. With a trust-based estate plan, the trust becomes the main vehicle. The main difference is that the trust is going to avoid probate. Whereas the will, you can have a will, but you're still going to have to go through the probate courts. You're still going to have to pay a probate attorney to probate that will and go through the hassle.
To take a step back, talk to some of the viewers may not know what probate is.
Yeah, so probate is a legal process where a will is admitted to probate court and an administrator is appointed over the estate who has official authority to act on behalf of the estate, to access the deceased's bank accounts, sell their real estate, and pay off any remaining debts and distribute the remaining property to the beneficiaries.
So what happens when there is no will? What goes on especially in regards to real estate?
Yeah, good question. So there's a bit of an analysis you have to walk through. First question, if there's no will, what assets are there? You kind of have to think about assets in two categories. You've got probate assets and then you've got non-probate assets. Probate assets include things like real estate, cash that you've got under the mattress, vehicles, jewelry, guns, LLCs, business interest stocks. All of those are subject to the terms of your will, or if you don't have a will, they're subject to the laws of the state of Texas as far as who gets those. So if someone doesn't have a will, it's a question of saying, okay, what probate assets do they have that would necessitate us to go to probate court? If the only thing you're dealing with is real estate, there's a good chance you could sidestep probate entirely and get away with what's called an affidavit of heirship. And that's a document signed by an heir plus two disinterested witnesses saying that these are the folks who are entitled to the property by law. That gets published in the real property records, and third parties like title companies will rely on that and accept that as proof of who actually inherits the property. So if the only thing you're dealing with is real estate and there is no will, good chance you could just get by with a simple, quick, easy affidavit of heirship. If there are other accounts, like let's say there's a bank account out there, you'd probably have to go through the probate court to get that, because no bank will release money to an administrator or heirs without an order from a probate court saying who the heirs are.
Oh.
So that's kind of the analysis you have to walk through. And then a further question is, let's say there's money there, let's say there's a bank account. How much is in that bank account? If it's only $5,000, well, it's going to cost you at least $6,000 to go through probate where there is no will. So it's almost not even worth going through probate at all. So those are some of the calculations that you have to make when you're determining what the appropriate probate procedure is.
So one of the things that kind of jumps in my mind is that really it's really for people that I think that are a little bit more well off or essentially wealthy. Is it really mainly for estate planning? Is it really meant for people that are a little bit more wealthier and how to divide their assets when they pass away, or what type of person really needs an estate attorney?
Yeah, not at all. So there is that misconception that estate planning is only for the wealthy, that trusts are only for the wealthy. That couldn't be further from the truth. The fact of the matter is, pretty much everybody needs an estate plan. It's especially important for people who don't have so much, because you want to make sure that what you do have gets to the right people and gets to them in an orderly and efficient manner. And we think of the death and assets aspect of estate planning, but there's also the lifetime aspect. So an estate plan is going to take care of you while you're alive. You've got things like medical powers of attorney, living wills, and things like that. And even if you don't have any money, you don't want to be in a position where you don't have a living will in place, and you're in a permanent coma, and there's no brain activity, and somebody's making a
So it's not just for if during death, but also when you're like maybe like you said, having a coma or something.
Exactly, yeah. So an estate plan, it's really two things. It's a plan that provides for your assets and loved ones upon your death, but it's also there for your lifetime. So in the case of disability or incapacity, your estate plan is also going to take care of you while you're living.
Okay. Yeah, I agree. I think it's really important because it's one of those things like you hope you have to have it right, because once you're gone, you can't go back and correct things because you're literally gone.
Right. It's only going to work one time, and it better work right that one time.
Yeah, because you have no supervision at that point of what happens from there.
No, not at all.
And so like I'm sure there's things like that you're aware of, like maybe like LegalZoom that does some type of things like estate planning. So like what's kind of like the difference between like things like LegalZoom and like someone like yourself, and like what makes you different from something like LegalZoom?
Yeah, so I jokingly refer to LegalZoom as my deferred client compensation payment program. Because
what is that? What do you mean by that?
Meaning basically that if someone does a will by LegalZoom, there's a good chance that they're going to end up paying me a lot to clean it up on the back end. Because the fact of the matter is, when you're doing DIY estate planning, you don't know what you don't know. It's very easy to make mistakes or miss certain issues. I generally don't recommend LegalZoom for estate planning. It can result in some bad outcomes. That said, there are certain circumstances where maybe it'll work fine. That's just one of those things that I would rather, if it's up to me, I don't want to leave that to chance. I want to get it done the right way the first time, and not leave a bunch of grief and heartache for my kids to sort out on the back end if I did something wrong in setting it up on my own.
I think too, like you said, like LegalZoom is like very, very cookie cutter, and it may not be up to date with all the changes that the state of Texas has every year potentially, and then every family has got like different assets, and it may not be able to like help with everything.
Sure, yeah. There are a lot of different things to consider. Like you said, it's cookie cutter forms. You're paying a price for forms. You're not paying for an estate planning attorney who can help you negotiate the unique issues that a family might have, like a kid with special needs, for instance. That's a big issue to plan around, because you don't want to give someone who has special needs a inheritance of any kind outright, because it could mess up their eligibility for public benefits. So there's a necessity to engage in planning for that. Now, there are certain circumstances where maybe the vanilla LegalZoom is going to work for you. I've just seen a lot of plans like that go wrong, so I generally recommend against it.
So when you mean like it goes wrong, like can you give me, I don't know if you can share like any examples of, like you said you've helped kind of help people like clean it up. Like can you kind of maybe you can't give specific examples, but maybe like a general idea of like where things go wrong with like people who do LegalZoom plans?
A lot of times people will print forms off of the internet, and they will edit them as they see fit and create lots of ambiguities that require a judgment from a court clarifying what the issue is. A lot of times they're not executed properly, so you have to execute a will in a very certain and particular way. And a lot of times people will come to me with these documents that haven't been signed right and might not even be valid at all, because they don't have the appropriate number of signatures, or maybe they weren't notarized, so we have to bring in extra witnesses, and it becomes more difficult.
Okay, so like kind of the two common issues that I'm hearing is like, one is just like it's just ambiguous as to what it means, and then two, they may have not done all the right procedures from, like, for example, like you're saying, it has to get publicly notarized, or some type of like have certain number of witnesses to say like this is or the documentation isn't quite perfect.
Right. It's when people start monkeying with the forms that bad things can happen, and then when they fail to get them signed properly, that can create a lot of extra issues on the back end. Also, you'll see people writing handwritten wills, which are legal. You can have a handwritten will. So you could take a napkin, a cocktail napkin, and write a will. And that's valid as long as it's in your handwriting and it's signed by you. Problem with that is that it doesn't have all of the necessary legal language to make it efficient to probate, and usually end up having to do a lot of cleanup work on the back end.
Okay, so it's valid, but it's also very hard to also enforce.
It's hard to probate. In fact, a lot of times it can cost 3-4 times as much to probate a handwritten will as one that's drawn up properly.
Okay, so your heirs will pay for it on the back end of like having the fees that are associated with that.
Pretty much, yeah. Because it doesn't have any of the language that you want to have in a will, like appointing an executor or appointing an executor to act independently, or having a residue clause, which means that you end up basically having to do a probate of a will plus an intestate probate, which is the kind of probate that you do when there is no will. So it's almost like 2 double probates in a lot of cases. So it can spiral into a big mess is what I'm trying to say.
Okay. So one of the things I'm kind of generally getting from you is that like having a will and having some type of plan for when you die is generally a good idea.
Yes.
And so I guess my follow-up to that is like, so say if someone wanted to like get started, what are the things that they need to do? Like, to just go straight to an attorney, or what is the thought process that need to go in their mind, or how do they go about like finding an attorney, or what's like the general process to get started of starting some type of plan? Even if you don't have like a big estate, like you said, probably just having a will is a good place to start.
Yeah, absolutely. Having a will in place is a great thing. As far as where to start with that, I would say reach out to an estate planning attorney, have a consultation with them. A lot of them will not charge you anything. They'll be able to kind of give you the 101 on estate planning. They'll alert you to issues that may be unique to your circumstances. They'll help you kind of put together a plan that achieves your goals, and you can decide if you want to move forward with them or not. But I think meeting with an estate planning attorney is a great first step. Also, it doesn't hurt to do a little preliminary research on your own. There's a wealth of information on Google, on the internet. So, get on Google, do a little Googling, see what you can find out, and that might lead you down the right path.
So say I like, okay, I want to get a will or do some type of estate planning. Like, when I'm like talking to people, how do I know if they're any good or not?
So one good way to vet people is the internet.
Okay.
Look for...
so something like Google My Business reviews or what?
Yeah, absolutely. I think that's a great first step to kind of narrow your search and find someone. If they've got a good number of reviews, that's a pretty good indicator that they're at least halfway decent. And then from there, it's a matter of speaking with them, seeing if they're able to answer your questions and adequately address your concerns. And you want to feel comfortable with them. You want to feel like this is an attorney I can work with and who gets me and gets what I'm trying to accomplish. So I would say, start with the internet, meet with one or two, and if you find one you like, then go with them.
Okay. Now, one of the questions I'm sure you get asked a lot, or a lot of your clients ask you about, comes around like cost, and maybe biggest, or just in general for attorneys in general, cost is always like a big factor because attorneys in general aren't cheap. So how does like someone get an idea of like what it would cost? I know it's like very hard with that because every case is unique, but if someone is trying to figure out how much it's going to cost, how do they like go about, like what are factors that might make it cost more or less, or how do they determine like what the cost of like an estate plan might be? Yeah,
so generally speaking, estate planners work off of flat fees. You don't often find that they do hourly work unless it's some unique situation. Usually they'll quote you a flat fee. And what flat fee they quote you is going to be based on what type of plan you want. So if you want a will-based estate plan, that's going to be a pretty bare bones package, and it's going to be on the lower side. A will-based estate plan is usually going to include wills. It's going to include medical power of attorney, durable power of attorney, HIPAA release, declaration of guardian, appointment of guardian for children, the living will. That's kind of your standard package. Those are all documents that should be a part of any estate plan. If you want something like a trust-based estate plan, that's probably going to cost you a little bit more. And then if you need to do any additional planning, let's say you need to do some asset protection, like you have significant real estate holdings, you might want to set up an LLC. Or if you have a bunch of real estate, you might want to consider a series LLC. So those are the things that can kind of shift the cost upwards or downwards. Generally speaking, you'll find that a trust-based estate plan is going to cost more. Certainly if it's for a husband and wife together, that's going to cost more than an individual. But that's generally how it works.
So generally, like, it's not an hourly thing when it comes to cost. It's like you kind of tell them, here's like all my assets, from my real estate assets to bank accounts to any other things or any other unusual scenarios, and then they decide, okay, here's like here's the flat rate of what it's going to cost generally.
Yeah, generally speaking. And when I have a consultation with clients, I have them fill out a questionnaire beforehand that gives me all the basic background facts that I need as far as who they have in their family, what their concerns are there any beneficiaries with particular health problems or special needs or issues with drugs or alcohol. Is it a blended family? All the things that I need to know about. And then I'll walk them through the 101 of estate planning. We'll talk about the different types of plans, and they can choose which kind of plan they'd like to go with.
Okay. And just to let our viewers know, like, right now this is just general advice and this is not legal advice. And Chris, you're only licensed in the state of Texas, right?
That's correct.
But can you do estate planning for other people outside of Texas, or how does that work?
I would not practice estate planning in any other state than that which I'm licensed. So if you live in California, see a California estate planning attorney. The laws are going to be different there than they are in Texas. I mean, the general principles are the same, but each state it's state specific.
Okay, there's just unique aspects of that state, and so you just don't have that kind of knowledge. Even though you're a licensed attorney, like, you don't know all the state rules for the other states. But not only that, you can't, even if you wanted to.
Right, I couldn't practice in California unless I was licensed there. So yeah, if you live in a state, get an estate planning attorney who is in that state and licensed to practice in that state.
Okay.
Yeah.
So what kind of got you into doing estate planning? Because in my head, is like, of all the attorneys, it's not the one that jumps out, or to me it'd be almost boring.
Yeah, a lot of people think of it that way, as a kind of sleepy practice area. So my parents are attorneys. I kind of grew up with some good exposure to what the practice of law looks like, and I got a sense of what practice areas are good and which practice areas are bad. I learned very early on that I didn't want to have anything to do with litigation. Fighting in court. That's just not my style. I prefer it when everybody gets along. And I sort of gravitated to estate planning for that reason. It's a good way to help people, give people peace of mind. There are no real urgent deadlines that you have with the court. We just kind of work at the pace of the clients. I'm on the client's timetable. It makes for a more relaxing work-life balance, and that's kind of what.
Yeah, you don't have your clients instead of being mad at you that this other person said this or did this, or like, we're not doing well in our case or something. You don't have those type of issues like if you were to do something in like litigation,
right,
or family law or something.
Right. Yeah. So on the probate side, I only handle probates where everybody gets along. If it's contested, you want to see a probate litigator, somebody who specializes in probate litigation.
Okay.
And that's a whole nother field of drama. If the drama doesn't come out in the family courts, it comes out in the probate courts, because money can make families behave in very weird and bad ways.
No, I understand. Money is it may not be you can't necessarily buy happiness, but it definitely helps having a little. And so because of that, money is a big factor, and people are definitely willing to fight for it.
Yeah, absolutely.
And so but so you got into that just because a lot of it is, like you're saying, just kind of like the piece behind it. I'm curious, like, for people like who are like aspiring to be an estate planning attorney, like how do they get into that? Say if I like just passed the bar, like, how do I get into this space?
So what I would recommend, if you're already out of law school, you've already passed the bar, find an estate planning firm and work for them, at least for a few years, to learn the ins and outs. This is not an area that you want to go into on your own without having first received the tutelage of a more experienced attorney. It's just, there are too many pitfalls out there for someone to just venture into it blindly. So I would say if you're wanting to get into estate planning, find a firm to work at. Find a boutique estate planning firm that does only estate planning, or at least does a lot of estate planning, where you'll get a chance to learn the ropes, learn from the best, learn on their dime, and then you can, if you want to go out on your own, you can take that knowledge.
I see. You're feeling like work for someone for 2 or 3 years, kind of get like do a little bit more schooling and have life experience, and then after that you have kind of like your options to kind of go from there.
Yeah, because if you start out on your own, you don't know what you don't know, and you're very likely to make some mistakes along the way. So, or at the very least, find a mentor, an estate planning attorney who's experienced, who can show you the ropes.
Okay, I think that's probably like a good life lesson for anybody who's getting into anything, that working under someone, especially where you can work on their dime for a couple of years, and then go out on your own, is probably the best way, not only just for an attorney, but also for generally in life.
Right. Yeah. Paid training. Basically.
Paid training. So I'm curious. So I'm curious if so I'm assuming that you probably have some type of will or estate plan, some type of plan. But what about I'm curious about your parents.
Yeah, they do as well. They have a trust-based estate plan. They've got real estate and other things like that, and a number of rental properties. So we've got a Series LLC set up for them to hold their various properties.
Did you help them set that up, or
I did, yeah. Yeah, free of charge.
Free of charge.
Just being a good son.
Okay, well, hopefully you're able to get a little extra when it comes to the dividends, because you were the one setting it up.
Yeah.
So you'll find out there too who's the favorite of the because you have a brother and sister, right?
Yeah.
So okay,
yeah,
that's funny. And so I think you were the only one of your 3 siblings that became an attorney.
Yeah. My brother is in accounting, and my sister is in cybersecurity.
Yeah. What kind of drove you into going into or just becoming a lawyer in general? Although, because you said the other 2 siblings didn't do that.
Yeah, I
it's a lot of work.
Yeah, it is. Like I said, I kind of grew up with it. I was exposed to it. It seemed to me to be something that I could tolerate and enjoy. And, you want to at least be able to tolerate your job. I happen to like my job, not just merely tolerate it. But I just sort of gravitated towards it. It seemed like a good career path that would enable me to help folks out, and it seemed interesting. The work seemed interesting, and so it appealed to me just intrinsically because it's the legal system is interesting to me, at least. So some people it might be boring, but to me it's interesting.
Well, what aspects about it are interesting?
Just the mechanisms of the laws, how they interact with the real world, how much gray area there is, just the whole thing. Really.
Okay. Yeah. So kind of walk me through, what does a typical day look like for you?
So it's a lot of meeting with clients. I'm in an area of law that's very consumer facing. I'm not like an attorney who is cloistered in some building who talks to only a handful of internal people in the company. I'm the face of my business, and so I'm meeting with people all the time. Typically with an estate planning client, I'm going to meet with them at least 3 times. So I'm going to have the initial consultation. We'll have a review meeting when we review drafts of the documents that I put together, and then we'll finally have a follow-up meeting to sign everything. So I'm seeing my estate planning clients a minimum of 3 times, and then with probate clients, when we're probating a will, that's going to be at least 2 meetings. When I meet them initially, and then when we appear in court together. So I'm meeting people a lot day to day. If I'm not meeting people, then I'm also drafting documents. So they hire me to create an estate plan. I've also got to draft the estate plan. Same with the probate stuff. I've got to prepare all of the legal paperwork for the hearings and so on and so forth. So general day, I'm meeting with people, I'm drafting documents, and then just doing all of the stuff that you would typically do in the course of an office job. So I'm responding to emails, I'm calling people, returning phone calls, and so on and so forth.
Okay. No, that makes sense. So it's generally the biggest aspects is it's just a very client facing aspect, and you're just talking with your clients often.
Yes.
In comparison to maybe in most other attorneys, or I guess most attorneys you're client facing in general, but
Yeah. Yeah. And, this is one where you do need to work with your clients a lot. I mean, this is their estate plan. It's a personal thing. So you do need to work closely with them to make sure that you're doing right by them and putting together a plan that's going to work for them.
So one of the things that kind of like popped in my head is, so in general, like kind of dividing up money is fairly straightforward. But one of the things that maybe is a little bit difficult, and one of the things that I'm most interested in is in the real estate space. So how is like real estate, especially if you have multiple heirs, like how does that get divided up? Or I'm curious of like how like your past clients, how they've divided up real estate, or what does that look like?
Yeah, so there are a couple of different ways it can be done. A lot of times, um, the will is admitted to probate. Let's say there's a will and there are 3 beneficiaries, 3 children, and then the person happened to have 3 properties. Well, the executor, once the will has been probated, could say, okay, each of these properties is approximately equal in value. I'm going to distribute 1 property to each of the beneficiaries. A lot of times, though, people would prefer that the executor just liquidate the properties and just distribute the proceeds equally among the beneficiaries. In fact, that's what a lot of people want specifically in their will and trust. They say, I don't want the properties going to my kids. I want my executor to sell them and just distribute the cash even, Stephen. And there are issues that arise if you suddenly make people co-owners who are siblings. They might not get along as far as what's going to be done with the property, right? So, one might want to sell it, one might want to hang on to it and rent it, one might want to live there. So very often it's better to just sell it, have an executor who's a point man who has the final say, who can say, no, we're selling it, no ifs, ands, or buts, and you guys are just going to get the cash.
No, that makes sense, because cash is it's easy to divide. And there's no like discrepancy about what's fair or unequal when you're dividing up cash. But with houses or like with other properties, it's hard to it's hard to decide, like you both want to like keep it, or how you run that particular, like that real estate might be like a business, like a storage unit facility. And so then it might be difficult to like how you have opinions about how you might operate differently.
Right. Yeah.
And so it's difficult. So I could see that. So it sounds like a lot of your cases, like most of the time, they ended with just selling the property or whatever real estate business, and then kind of just take the proceeds from there.
Yeah, and a lot of times we'll set up the estate plan so that the executor or the trustee has the leeway to use their own good judgment at that moment and say, okay, this is the way that things are going to be. This is the fairest. So I'm just going to go ahead and do this, and you guys have no control, and you can't go against my will. So maybe it makes sense at the time to sell everything. Maybe it makes sense to distribute things and use cash to kind of balance it out to make sure that everybody's getting an equal portion. So the executor has some leeway in making those distributions.
Okay. So one of the questions I think I wanted to ask too is like, what are the biggest like mistakes or misconceptions or problems that happen a lot with estate planning?
Good question. So there are a few. There are more than a few. One thing that happens a lot that I see in my practice is that people forget to put things in their trust. So in order for a trust to avoid probate entirely, you've got to actually put all of your stuff into the trust. It's like a cookie jar, and you want to put all of your cookies in the cookie jar. You don't want to have any laying out on the counter. It often is the case that somebody maybe put most of their stuff into their trust. They put their real estate in the trust. They put their LLCs in the trust. They put most of their bank accounts in the trust. But maybe they forgot about this little pygmy bank account out there, and that was outside of their trust at the time of death. So now you've got to go through probate to get that account back into the trust so that it can be distributed in accordance with the terms of the trust document. Other mistakes people make, I always avoid or I always caution people against co-trustees and co-executors. It's usually not a good idea to have 2 people in that role, because there's the possibility that they
may not agree.
Right, exactly. So you don't want too many cooks in the kitchen. It's better to have one point man who has the final say. You don't want to have you generally don't want to have a committee of people, because the potential for conflict is just too great.
Yeah.
Also, a thing I see a lot is people naming their minor children as beneficiaries on things like life insurance. and IRAs and 401ks. That's a terrible idea because minors technically can't inherit property. So if you leave a minor your life insurance policy and you die, they won't be able to reach that money until they're 18, or unless a court-appointed guardian is in place to get that money for them, which is a hugely onerous process.
Yeah, and so if these things are done incorrectly, basically what's going to happen is that they're going to have to spend money in legal fees, or like just the legal process. They're going to have to pay in that way, and then a lot of your money that they're getting is going to get cut by legal fees.
Yeah, certainly legal fees will eat into it, and even just as bad as just the headache of having to go through it and sort all of that out on the back end. That's a pretty burdensome process, especially a guardianship. That's got to be one of the most onerous legal processes you can go through.
Yeah, especially during that, especially when someone passes away, it's already a difficult time already. And so it's not something that you want to be like going through.
No, certainly not.
I don't know if this is like a dumb question to ask, but is there a difference between an estate planner and an estate planning attorney?
So all estate planners are attorneys effectively. So they're estate planning attorneys. Now there are some other collateral professionals who assist with estate planning indirectly. So financial planners, that's part of the overall puzzle. They handle the financial aspect. But estate planning is really a legal concept more than anything. So it's going to be an attorney.
Okay. So it's not like there's like attorneys and then non-attorney versions. It's
correct.
Like,
yeah.
Okay. You have to be an attorney to do any type of estate planning.
You do. Yes.
Okay.
Yeah.
I wasn't sure about that.
Yeah.
And I'm curious. So like you kind of talked about this a little bit. Like what's your advice to somebody who has a lot of real estate and is doing their estate planning? What are kind of like general principles that you would suggest? Because a lot of my viewers are into real estate development and real estate investing, so they have a lot of real estate, and so they don't have. When it comes to planning, what is your thoughts around that?
Yeah, so there are a lot of things you can do. With real estate, you've also got to be cognizant of asset protection. So usually...
asset protection?
Asset protection.
So what do you mean by that?
So let's take LLCs, for instance. You want to protect what you have while you're living and limit your exposure to liability in the event that a tenant or some third party or contractor sues you. So LLCs are a big part of planning for real estate investors. Very often what we'll do with real estate investors who have significant holdings is we'll set up a trust-based estate plan. We'll put each of their real properties into an LLC and then assign those LLCs to the trust. And that gives you great liability protection. So, if something goes wrong with your property, the litigator can't go after the rest of your assets. It essentially limits it to that one property. General practice is to put one property in one LLC, one per LLC. You could put multiple properties into one LLC, but the problem is that's essentially like putting all of your eggs in one basket. So if something goes wrong in connection with property number one, a litigator could go after the equity in all of the properties that are inside of that LLC. So usually if we're doing estate planning for real estate investors, we'll set up a separate LLC for each property. If you have a bunch of properties, if you have, let's say, 8, 9, 10, 15, 20 properties, then you're probably better served with a series LLC. Because at a certain point, having that many LLCs, having 10 LLCs becomes a bit of an administrative burden. So you've got a problem come tax season, because it's a
every
pain.
year.
Yeah. Not to mention you've got to maintain bank accounts for 10 different LLCs and have a no franchise tax due form every year. So the solution for that is a series LLC, which is designed to cut down on a lot of the administrative burden of having a multiplicity of LLCs. So the way a series LLC works is you have one master LLC, the series LLC, which effectively functions as a holding company. Within that master LLC, you can create any number of series, and these are protected series that function just like an LLC. And you can create as many series as you have properties, and so you can put each of those properties into its own series within this master LLC. And it creates a firewall of asset protection between each of these properties and puts a wall between these properties and you personally. You know, when it comes to asset protection, insurance is always your first line of defense, but you do want to make sure that you've got LLCs in place to protect your real estate investments as a part of your estate plan.
Yeah, that sounds like good advice also too, even not just for estate planning, but also just like while you own the property to have an LLC. Do you generally advise for like people who buy investment properties or buy like lands to put it in an LLC rather than their own name?
I would consider it a necessity almost from a risk reduction standpoint. I mean,
like what kind of risk? Like, say if they bought a land, like the land isn't gonna like hurt somebody.
No, it's really if people are going to be on the land or if you're renting it. Yeah, vacant lot. You could put it in an LLC. But it's really more for property that you're renting or developing in case somebody gets hurt there. I mean, you could get some marginal benefit from having a vacant land in an LLC in that if somebody sued you personally, they couldn't force you to liquidate the property that's holding that vacant. They couldn't force you to liquidate the vacant land that's held in that LLC. The worst they could get is what's called a charging order, which means that anytime you distribute cash from that LLC, you have to give them some of it. So you do get some marginal protection.
And then, so especially if somebody sues you, if you have like your other properties in LLCs, they can't necessarily go after after those properties necessarily.
Yeah, if let's say you got in a car wreck and they sued you, they couldn't force you to liquidate the properties in your LLCs in satisfaction of their judgment against you. The underlying policy is that courts don't want to interrupt the business activities of companies like LLCs, so they're not going to let somebody get in there and force you to sell a business asset and pay them. They can get a charging order, which means anytime you make a draw from your LLC in the way of profit, they could be entitled to some or all of it, but they can't get the asset.
I see. So it gives you some protection if like something major happens and they're coming after your assets. It becomes harder.
Yes. So if you do get sued personally, then it's harder for them to get to it. And that's really kind of what asset protection is about, is putting up a bunch of barriers to make it hard for people to collect and make them just go for the low-hanging fruit, which is your insurance policy. It's always a good idea to have a robust umbrella policy because insurance is always going to be your first line of defense. And plaintiffs' attorneys by nature are pretty lazy. And so if you have a policy there that would satisfy them and their client, chances are you can get them to stop there, hopefully.
Okay.
Yeah.
I'm curious, we talked about it briefly, but I want to kind of get back to it, is about topic about like trust, because people are always interested in terms of like what trust, kind of like what trusts are and like how they work. Like, do you have to be 18 in order to, at that point, to receive money if for your heirs, or what? Can you talk to me about trust? Kind of give me like the 101 behind it.
Yeah. So in a nutshell, what a trust is it's a legal relationship between a trustee, who's basically the manager of the trust, and then the beneficiary, who is simply the person who benefits from the trust. And then you have the grantor, who is the one who creates the trust and puts assets into the trust. In the case of a living revocable trust, which is probably the most common type of estate planning trust out there, it kind of works like this. So let's say there's a husband and wife. They set up a revocable trust. During their lifetime, they're the trustees of their trust. They're also the beneficiaries of their trust. They continue to use the trust property the exact same way they do now. The only difference is that it's titled in the name of this trust. So if one of them passes on, the surviving spouse doesn't have to go through probate court. They can come see me or an attorney like me. We draw up 1 or 2 documents related to the administration of the trust, and then they can walk out and be done. And then likewise, when the surviving spouse eventually passes away, their successor trustee, whoever they've named in their trust document to step in and manage things and distribute the assets, that person can immediately take charge without having to go through probate court. And to your question, yeah, you can attach stipulations to it. So in the case of younger kids, a lot of folks would not want their 18-year-old getting a sudden windfall. If I got $1 million when I was 18, probably wouldn't have any of it today. So you can attach strings to it. You know, you can say, I want my kid to have half of it at age 25, and then they can get the balance at 30. And all during that time.
So they can stagger like when they get
absolutely. You can stagger it in a number of different ways. You can have it all distributed at one time. You could break it into thirds. You could do a bunch of different things with it. And all during the meantime, your trustee can still make distributions to your beneficiary for their health, education, maintenance, support. So, you know, your trustee can pay their college, can, you know, help them out with a down payment for a house, can, you know, your beneficiary can come to your trustee and say, hey, I need a car. And the trustee will say, okay, yeah, I'll buy you a car. I won't buy you a Ferrari, but I'll buy you a car.
Okay.
So they can otherwise, you know, take care of them and provide for them until
so the trustee would have to do that.
Correct.
So the thing is just like, that's a tough decision you have to make, is like who your trustee is going to be to kind of make these decisions. Yeah. And they have to be like younger than you, so they're not likely to have passed away.
Yeah,
or something. That's an interesting like decision.
It is a dilemma for some people. Usually what people end up doing is selecting a close family member, maybe like a brother or somebody, or even a parent. It's okay actually to have someone who is older than you as a trustee. A good rule of thumb for estate planning is plan for the next 5 to 7 years. And then, you know, after that time lapses, you can take
redo it.
Yeah, you can take your estate plan off the shelf, dust it off, read through it, and say, you know, okay, what's happened in the past few years? Are the people I've named in these roles as trustee and so forth, are they still suited to this role? Do I need to replace them with someone else? So I would say it's okay to name somebody older than you, as long as you can envision them doing the job within the next few years. And it's also a good idea to have several backups in case the person you first named.
Okay, so you could have like ranking order of like your top 5, and then whoever's still alive in order.
Yeah, because you never know what the future holds. The person you first named, they might die, or maybe they become incapacitated, or maybe they move away, or maybe they just don't want to fool with it. So typically a good rule of thumb is have at least 3 backups in place.
Okay.
Yeah.
One of the things that was interesting that you said is that you could have is contingent. I've always thought about, cause something that I've thought about is like if I have kids and like if I were to pass away, I don't know if I want them to have all my money necessarily. Like what I mean is not necessarily like donating it, but I feel like I want them to earn it in the sense of like just being my son or daughter doesn't like give you automatic access necessarily. Like things like having conditions like if you go to college, then I'll give a percentage of it potentially, or if you do something like say if I say like if you do like a year of martial arts or something, then I could give you a certain percentage or a certain amount. I'm curious if there's like ways to do things like that where like you have to have like maybe like certain achievements.
Absolutely, yeah. Lots of clients want to attach strings like that or milestones.
Yeah.
You have to be careful with that though, because, you know, take the martial arts example. What if your child becomes disabled and can't physically do martial arts? Then what happens?
I see.
So it's okay to have milestones, but or you know, a common one is I want my kid to graduate from an accredited university. Well, what if they end up taking a different path in life that's equally fulfilling and worthwhile, but just isn't that? Are they now going to be deprived of their inheritance for that reason? So it's possible to do things like that, but generally you want to think broader, just because you never know what the future holds. And if you do attach strings, then you have to plan for a bunch of different contingencies.
I see.
So those things tend to break down the more specific they get. But you know, if it's possible.
So it's possible, because in my head it's like that's something that I would like think about. Like, so what I would do. So theoretically, if I was in this situation, and I had kids. Even though you're saying we're only 5 to 7 years from now, even though I'm not like that close to in that area of my life, but if I were gonna do it, I would have like 10 different things. And if you get like 1 or 2 of these things, then you could get access to the money at this age or something.
Yeah.
Like, so like you said, if like I'd have like a couple of things. Going to college for 4 years and getting a bachelor's degree gives you like a milestone. Or if you don't do that, doing like some type of like trade school or some type of like equally equivalent, or have like a bunch of things and they choose the one that like they both most align with. Because my worry is that like as a parent is that my kids are going to get spoiled.
Yeah.
And so, and like you said, it's also about like getting the money too soon. If they get them when they're just like turn 18 or something, I feel like they're just gonna blow that money and they're gonna lose it. And especially when they didn't earn it, they didn't do anything to earn it.
Right.
And so that's what in my head is just like, especially if I give to my heirs that are young, that I want to make sure that they use that money wisely.
Mm-hmm. Yeah. Yeah, that's a legitimate concern. And, I always tell clients, your kids best. And so if there are certain provisions that you really want to be in there, then we'll find a way to make it work and create a workable document for you.
Okay. But in general, your planning is somewhere between, when you do like a will or estate planning, it's just for the next 5 to 7 years. You shouldn't be planning further out than that.
You can. I think that's just a good guideline, right?
Okay.
So that doesn't necessarily mean that you need to update your estate plan every single time 5 years has lapsed.
But you say you think it's pretty safe to say like every decade you should probably update it.
Or certainly review it.
At least review it.
To make sure that everything is still good. I mean, you'll certainly...
Because you'll probably have new assets at that point. By then you might have new kids, and so
right,
they don't want to be left out of the will.
Right, and certainly you should reevaluate things whenever a major life event occurs, like a death. Maybe you get remarried. Some circumstance happens. Somebody gets disabled. Any major life event is a good reason to revisit your estate plan and evaluate whether it still works or whether some additional changes are needed. Or maybe there's, in the meantime, a change in the law that necessitates updating things.
No, that makes sense, because there's so many things that can happen in your life, and it's just like what you did like 5 or 10 years ago, you might be in a very different place in your life.
Yeah, absolutely. Yeah, planning for someone in their early 20s looks drastically different than a plan for somebody in their 40s or 50s or 60s.
I see.
Yeah.
Can you kind of walk me through, like, so I'm sure you have clients of all different ages, and so like what are kind of the plans of someone in their 20s versus like someone in their plans in like their 50s or something?
Yeah, so a plan for someone in their early 20s might look a little bit different. Let's say they're out working their first job. They're contributing to their 401k. They don't have a ton in the way of real estate. They don't have corporate stock or business interests like LLCs. For them, they might be fine with a will-based estate plan, have a will in place. If they own a home, they could do a transfer and death deed for the home, naming their desired beneficiary.
So what's a transfer and death deed?
So that's a deed that allows you to name a beneficiary to receive a piece of property immediately upon your death without having to go through probate. So the moment you die, it instantly transfers to this person and avoids the probate process entirely. So that's an attractive way to set up an estate
Yeah, based
plan.
off what our conversation so far is, like, going through probate sucks.
It's not fun. I will say it's not as onerous as some states like California.
Okay.
Like California probate is an absolute nightmare. Texas, it's a little more streamlined, at least if you have a will, but still not a fun thing to go through. And you're still going to have to pay an attorney, $4,000 to do it if there's a will. So it's something that's, in my mind, worth avoiding if you can.
Okay.
So in the case of a younger person, one way to avoid probate is have a will-based estate plan, have all of your ancillary documents like your healthcare powers of attorney, durable powers of attorney. Go to your financial institutions like your 401k and name your beneficiaries. Go to your bank account, name a pay on death beneficiary. And then so if you've got beneficiary designations set up on all those financial accounts, and if you own a home and you've got a transfer on death deed for that, then you don't have any probate assets that would require you to go through probate. So that's one way to set up an estate plan to avoid probate and get your assets to your beneficiaries quickly.
Okay.
Now, there are some downsides to the transfer and death deed. For instance, you may not want 3 people to suddenly become co-owners of a property. If you name your 3 kids as beneficiaries on a transfer and death deed, or a TOD as we call them, you run into that situation where you suddenly made 3 people co-owners of a property who might not get along at all.
Or even not get along, but just not agree.
Exactly, yeah. They might have totally different ideas as to what they want to do with it. So usually you want to use a transfer and death deed when you're just giving a property to one person.
Okay. I see that's been a consistent theme in general. Is like it's hard to divide stuff, so it's just easier to do proceeds in cash, and then like giving something to like 3 different people or multiple people is very difficult. Especially if it's not cash, where you can't easily split it up.
It can be, yeah. And one of the name of the game, or one of the names of the game with estate planning, is planning to avoid conflict, to minimize the potential for conflict, and avoiding making people co-owners is a good way to avoid conflict.
I see. Okay, I see why you became an estate planning. Like you said, you're trying to avoid going through litigation and any type of conflict.
Right.
And especially that's essentially what you're doing, to do things to avoid litigation in the first place.
Yeah, I try to avoid the courtroom at all costs. So, and that's part of what any good estate plan is going to do. It's going to minimize conflict. It's going to make things smooth. It's going to maintain family harmony after you're gone.
Okay. So we're getting kind of near the end of it, but I wanted to ask you a few kind of rapid fire questions to let people kind of really know a little bit of it more about you.
Sure.
And then we'll kind of end it from there.
Sounds good.
So I got a question for you. Is there any gift that you've any book that you've like given to anyone, or any like gift that you've given to anyone recently that's under $50?
Any gift?
Yeah, any gift.
I gave my sister a gift card to King Arthur Baking because she likes to bake.
Okay. That's funny. And I'm curious, so what do you, like, people that, the friends who know you, what would they say they would like to describe you? How would they describe you?
Pretty easygoing, loyal guy, I guess. A problem solver.
Okay.
Yeah, off the top of my head, I don't know. They might have different ideas.
They might have different adjectives to describe you.
Yeah.
Okay. And then I think that those are just like the 2 questions I had. We'll leave it at there for now. If people want to get in touch with you, what's kind of like the best ways for them to get in touch? Best
way is usually through our website, thedaveslawfirm.com. We've got a contact form there, and there's also my email on the website as well if you want to email me directly. I'm almost always glad to chat or answer any questions that folks have, as long as I'm not in a meeting or in court. I can almost always take it.
And so I'll make sure to include that in the show notes from this episode, so that it'll be included in the description as well, so that if the people want to reach out to you about estate planning, or just to have a short conversation and see if it's the right fit for them, then they can. That's a good way for them to reach out to you.
Cool deal.
Okay, so with that, we'll kind of come to an end. Thank you guys for watching, and please like and subscribe to my video and my content, and I'll have more podcast episodes come to you soon.